This afternoon, a court of appeal in Cape Coast has struck out the appeal by embattled Assin North MP James Gyakuye Quaysons for non-compliance with court procedures. Mr. Quayson filed an appeal challenging a High Court ruling that declared fresh elections to be done in the constituency and ordered him not to hold himself as Member of Parliament for the area. Delivering her ruling just a couple of hours ago, the presiding judge, Her Ladyship Irene Charity Labi, stated that the embattled MP failed woefully to comply with the court's directives to submit his written submissions within the stipulated time. The judge further ordered that all applications, including the stay of execution before the panel in relation to the Assin North MP, have been struck out. That definitely means that there are implications for the MP and also the NDC minority in Parliament. So what's the meaning of this? We'll get shortly the latest from the Central Region from Richard Kujunyako, who is joining us on Zoom. Also the Director of Legal for the NDC, lawyer Abraham Amaliba, is joining us for a reaction on this. But first, let's hear from Richard, who was in court today, has all of the latest in terms of what transpired in court today. First of all, Richard, give us a breakdown to what's happening there in the Central Region and what reactions you're getting after this landmark ruling that we're getting through from the court.
So, Blessed, the Court of Appeal in their last sitting adjourned the Assin North MP's case to the 22nd of March, that is today, after counsel for the MP for the Assin North, Chachikata, sought clarity on why the court had decided to use CI 47 to deal with the application for stay of execution, which was pending before the court. So before that, the court's registrar had issued a certificate of non-compliance to James Gyakuye Quaysons and his lawyers on the 24th of January 2022. So it was to the effect that they were issued with Form 6, and which is just a notice of dispatch to the records of the Court of Appeal. This means that all the records at the High Court, which had to do with the original petition, had to be dispatched to the Court of Appeal. So they failed to do that. So the MP had within 21 days to file his written submission, but he did not comply. On that basis, the court's registrar had to put in or issue a certificate of non-compliance, indicating that there was nothing, absolutely nothing. And so the case had to be struck out. But today, before the proceedings began, lawyer for the Assin North MP, Chachikata, indicated to the court that they had filed 3 fresh applications, one of which sought to disqualify the presiding judge from sitting on the case. But the panel indicated that such applications were not before them, and based on that, they will go ahead to deal with the matters before them. So the judge went ahead after some heated argument between lawyer for the petitioner Frank Davies and then lawyer Abraham Amaliba. It went on and on, but the judge dismissed the appeal before the panel and ordered that all other applications, motions that hinged on that particular application appeal has also been struck out as well. So according to the presiding judge, one cannot put something on nothing and expect it to stand. So once the roots of the matter had been dealt with, it means that that one had been dealt a hefty blow. So it means that all the branches, the stem and everything had also been rendered null and void. And so that was what really transpired in court.
Interesting concepts there from the presiding judge. But what reaction have we been getting from both sides of the divide? We know that this is a highly political case, and so the political parties will be represented in court. What transpired after this ruling was given?
Well, incidentally or interestingly, today it was almost an empty court. But when we started the proceedings way back last year, the court had always been filled with party supporters, sympathizers. Even at a point, they had to even buzz people to the court premises to jubilate or otherwise of the decision that will be taken on that day. But today, that one was conspicuously missing. After the court ruling, the lawyers sat in their cars, but there was actually a reaction from the side of the petitioner. They said that they knew from the outset that the MP had no case, and so it was a way to buy time, and that is why they had to resort to the Supreme Court and other processes in order to delay the cases. And so they are waiting for the Electoral Commission to kick in motion its processes to declare the seat vacant and then actually go ahead to organize a by-election in the Assin North constituency. So that is from the side of the MPP. We spoke with the MPP Regional Secretary, who incidentally represents the petitioner in this very case, and they said that they are very happy with what the outcome of the case, and they are waiting on the Electoral Commission to say something before they also act.
Great. So what this simply means is that going forward, the expectation of the judge is that James Gyakuye Quaysons will no longer be regarded as Member of Parliament, right?
Yes, so once there is no application that has been filed or there hasn't been any relisting in court, then it means that the judgment of the High Court still stands, that the orders that were given last year that Mr. James Gyakuye Quaysons should not hold himself as the MP for the area and that fresh elections ought to be conducted in the Assin North constituency, all of these still stand. And so the judgment creditor, being Michael Ankuman, in fact, can go ahead and execute that kind of judgment.
Let's see what this means for a political party, which the Member of Parliament, now no longer a Member of Parliament as we speak, thinks about this. Joining us now is Abraham Amali, but I'm grateful, Richard, for the latest. Let's hear from the party, the NDC, and what they think about this. Council, it's good to be speaking to you at this moment. So what's the reaction of the National Democratic Congress to this ruling that we're getting from the court?
Well, it's too early now. Our lawyers are on their way coming to brief the party at a meeting. There's a meeting ongoing now. And so we await to hear from them when they arrive. But we have also heard from the reports of what you are talking about, that we await the arrival of our lawyers who are actually driving from Cape Coast to join us in this meeting.
Is that to say that the NDC may take up another contest on this matter, challenging the ruling that we're seeing from the Court of Appeal?
Well, that's a strategy that I may not like to divulge, but I heard your reporter talk about relisting. That is also possible. It's possible to, because the notice of appeal was struck out. It wasn't dismissed. It was struck out for non-compliance. What it means is that it's possible that a motion for relisting could be done, and then the notice can be brought back again. And so, as it is now, I wouldn't say it's all over yet, because the lawyers are on their way, and we are waiting to hear what they have to say.
So, going forward, for the political party, as opposition members, obviously in Parliament, the implication is that your numbers may further dwindle if this is supposed to be allowed to go through. Or perhaps all of this will be subjected to a new election.
As we speak now, yes, that is the implication of the judgment. But this could change. This could change if we file for relisting of the notice of appeal and if other processes are filed. But as we speak now, the effect is what you have just articulated.
Yes, how ready, and I'm just interested in finding out how ready the NDC is for a runoff in the area. This area, politically speaking, is tagged the swing area. So that could mean misfortune for the NDC, isn't it?
No, from our studies, the MP who is eligible to stand again, don't forget that the matters they are talking about is not as if he's under any disability now. He's not under any disability. If the seat is declared vacant, he's eligible to stand again. And so my understanding from our research is that he's a very popular person, and it's possible that when we repeat him, he will be able to annex the seat for us again.
The Speaker of Parliament somewhere last year told the general public that he would not effect the initial rulings of the lower courts. The fact that this was a premature case, there was a need for us to, first of all, see the outcome of the appeal that's going on in court. Now, at least, we do have some determination on that matter. Will the NDC now instruct the Speaker, who obviously belongs to the NDC, to now respect the decision of the courts?
The NDC does not instruct the Speaker. And in this particular matter, the NDC is not a judgment creditor. And so the NDC will not be taking it upon itself to be executing this judgment. I heard your reporter talk about the fact that the judgment creditor will be the one to initiate all these processes. So the NDC does not instruct the Speaker. The Speaker was right when he said that.
Council, I'm sorry for cutting through, but that's obvious. We all know that the NDC cannot instruct the Speaker of Parliament, yet this is someone who's a member of your political party. In fact, you have MPs in Parliament as well who believe in the concept of rule of law. So I'm just asking if you'd ask perhaps your leadership in Parliament to trigger the processes so he be removed.
I've just told you that the effect of the ruling is that he is no more a member of Parliament as we speak now. But if processes are filed, I indicated to you there's a chance that you could file a motion for relisting of the notice. If those processes are reactivated and is granted, the matter is back on the burner. And so you should understand where I'm coming from. We do not instruct the Speaker to declare seats vacant. But the Speaker was right when he said that because the matter was on appeal, it was premature for him to be declaring the seat vacant. And so if no process is filed in court to reactivate the issues we are talking about, that's a notice of appeal, then he can go ahead and declare it vacant. But if processes have been activated, he still needs to wait to the final conclusion of those matters. So that is my view on it.
Number of outstanding litigations going on. We do know that this is not the only case that the NDC is putting its eye on. We know that there are some other constituencies as well where similar cases are happening, but in a different way. What's the expectation of the NDC on all of these cases that are pending before the court?
Well, we just think that when you look at the Techima South, we think that we are on good grounds. The reports emanating from that court indicates that, yes, we are on good grounds. The evidence that we have supports our case. And so in that particular case, we expect the results to go, or the judgment to go in our favor. Others are ongoing. There's Sefiru also, which most people don't know, but the trial is starting tomorrow. That is also another matter, which is a straightforward matter where a ballot box was snatched, and the contents of those ballots were not added to the final result, and yet somebody was declared a winner. And so these are all matters that we are waiting to hear from what the court will say.
And finally, to claims that, I mean, you should have known that this would have been the outcome of what we're seeing today. The fact that your candidate at the time was not eligible to contest the elections.
No, that is wrong. It's because you are buying into a certain propaganda. We have maintained that when you look at the People's Representation Act, the time of qualification is at the time of election, 7th December. The time of qualification, and I can show you the section 20 of the People's Representation Act, the time of qualification is not at the time of nomination. So we still believe, because the law, I've quoted the law that supports our case. The time of qualification in our case is at the time of election. And at the time of election, our candidate had qualified and he had gotten his documents ready. They are saying that it should be at the time of nomination, and that is where the difference arises.
What's your expectation from the meeting that will be happening in a few minutes from now?
Well, I'm not able to speak to that yet. But, we are in a meeting every Tuesday. The party has a meeting, and the party would take briefing from the lawyers who are on their way.
All right, then. I'm grateful. Head of Legal for the Opposition National Democratic Congress, Abraham Amaliba, speaking to us there.